Hello, everyone. Good morning, good afternoon, good evening. Here we are again. I don't know. Oh, we've got a couple of people jumping on. This is completely unexpected. I did not know that there was another Sarah Boone Motions hearing today. I did not know until I'm sat there eating my lunch and I see both Law and Crime and Court TV pop up with streams about to start. So I've no idea. Don't ask me. No idea what this is about. I was under the impression that yesterday's hearing, which was very informative, I went back and listened to it again after I finished the Leilani live stream last night. And I caught most of what the judge had said. But yeah, I love that judge, Michael Kranick. Great judge. Absolutely spot on, in my opinion, with the way that he deals with things, because he wants law. He wants everything to be backed up with law. Wouldn't that be nice if all judges demanded? Because, you know, it keeps the attorneys on track and it makes the judge's life easier because he or she, where relevant, can look at the law and think, yeah, all right, this argument is backed up by this, this, and this, but what about this, this, and this? And they can have a civilized debate about it, which is what happened yesterday. But I thought that it was the last motions hearing. I thought they got stuff sorted, as much as anything can be sorted with Sarah Boone. Will this trial ever start? Exactly. Will it ever start? I was under the impression that they were still in jury selection, but that was probably going to conclude like this morning. But instead, you know, it's only 9 a.m. in Florida. So I don't know. I was under the impression that jury selection was going to continue into this morning. And then if they were done, they were going to swear in the jury and then get going with the opening statements. Now, I didn't put a scheduler up because I wasn't sure whether it was going to happen this afternoon, like Florida time, or whether it was going to push into Friday. Because there was that, if it doesn't, they don't quite finish jury selection, it's going to push into Friday. So I didn't set a scheduler up at all. I'll just play it by ear. Let's see how it goes. But we've got this motions hearing now. So I've no idea. I've no idea what's going on. And for those following Leilani Simon, I do have a scheduler set up for that, about to go live in about 15 minutes. However, the judge did say that they were starting at 9 a.m. But then I've noticed Law and Crime Network, their scheduler, is starting at 11 a.m. Georgia time. So I have no idea what's going on in that trial either. But I set my scheduler up based on what Judge Tammy Stokes said to us all last night, that she was starting at 9. Now, we have that half-hour delay, so it's 9:30 for us, Eastern. So I don't know. I don't know what's going on. Maybe Sarah's asking for more snacks. A toaster. She wants a toaster to warm her Pop-Tarts. Yeah, they're going to have a hearing on the safety issues related to having a toaster in the courtroom. She wants to sit there munching Pop-Tarts. Do we have Pop-Tarts here in the UK? I think we do. I know what they are, so I think we do. It's not something I've ever bought, but anyhow. See, this is the Law and Crime scheduler for Leilani. Hold on, let me get it up. Where is it? Oh, there's loads of people live. Hold on, I can't even find it. I absolutely cannot find it. I don't think my notifications are going out because I'm posting so many videos. Like I'm doing recaps of yeah, see, look. Law and Crime, Leilani Simon trial, 4 p.m. That's my time. But so that's 11 a.m. Eastern. So what's going on? Why have they got theirs set for 4 p.m. stroke 11 a.m.? Don't know. So I'm going to keep an eye on that. Because there's no point going live on Michelle After Dark because I'll be over here. And there's no point going live on Michelle After Dark if there's nothing going on. So I'll keep an eye on it. And then see what happens. See what happens. But what I am doing, for those who can't sit through an entire trial, a few people have asked me to do recaps. And honestly, after I've done like 8 hours on the live streams, I am literally too tired to go straight into recapping the whole day. So what I've decided to do is this. I'll show you what I've decided to do. I'm taking out like interesting pieces from each day. So days 1 and 2, there was nothing really. It was all necessary testimony from like law enforcement, but there was nothing really outstandingly, worth making a special video on. So I'm taking out testimony that is particularly interesting. So I've posted the forensic anthropologist's interview on its own, and then this morning they're not getting very many views at all. I know that loads of people, like way bigger YouTubers than me, are covering this, so I'm not going to get very many views, but I don't care. But this is Leilani's rant, massive rant that she had with that FBI agent. So they're there for people if you want them. So they're posting on this channel, Michelle Walks, but I'm putting them all in the Quinton Simon playlist, which is on Michelle After Dark. So they're all there in one playlist. Just for anybody who wants recaps on Leilani but doesn't want to sit through the trial. So that's as good as I can do, I'm afraid. And I'll do the same for Sarah Boone once the trial gets going proper. So that's what, yeah, yesterday was 10 because the judge had something to do beforehand. But she absolutely said at the end of yesterday, she told the jury that court was going to start at 9 a.m. So the jury are under the impression that court is starting at 9 a.m. So I'm not sure whether Law and Crime Network have got it wrong or whether there's been, I don't know, something that I've missed. I've no idea. I'll check to see what Court TV's scheduler says for Leilani. Oh, no, you see, look. Latest from Court TV. Their scheduler is due to start at 2:30, so that's 9:30 a.m. So I think Law and Crime Network have got it wrong. So I do have my live stream set up on Michelle After Dark for Leilani. So as soon as they go live, as soon as anybody streaming the trial goes live, then I'll go live. That's the best I can do, I'm afraid. So we're now waiting for court in Florida. Waiting for court in Florida. This is the problem with trials. There's so much waiting around. So much waiting around. I'll just get my other computer set up properly. Just in case I'm right. And court is starting at 9 in Georgia. Right, I'm good to go. Good to go in Georgia. Good to go in Florida. So, how's everybody doing? Who's following both trials, like Leilani and Sarah Boone?
The tragic story of a little 20-month-old boy.
Didn't mean that to happen. All right. Come on. Come on, someone. Someone make something happen. Trying to keep up on all. Yeah. And Delphi. Absolutely, and Delphi. So I did post a short video over on MichelleAfterDark this morning. There's a new court order if you want to go and check that out. And they are swearing in the jury today. Opening statement starts tomorrow. So throughout the trials, you know, Leilani and Sarah, once Sarah gets going, I will be doing Delphi updates throughout the day if anything comes out. Of course, as we know, reporters and the public are not allowed to take phones in or laptops in, so the only updates we get are during breaks when a reporter can just run out and tweet. That's all we're going to get until after court finishes. And she's not planning to finish court until 6 p.m, which is 11 p.m. my time. So that's going to be really difficult to keep up with. I will try my best. Don't think Sarah Boone is going to take 3 weeks. Well, it was scheduled 3 weeks, but that was including jury selection, I think. I think the trial itself is due to last like 2.5 weeks. But based on the motions hearing yesterday, the judge is allowing the domestic abuse defence. It was a very interesting, something's happening. It was a very interesting discussion that the judge had with the attorneys. But he sided with the defence and said, yes, you can include it. However, you have to set the foundation. You have to set the foundation first. So basically what that means is Sarah Boone is going to have to testify to how threatened she felt about George getting his hand out of the suitcase. But she shot herself in the foot. In my opinion, even though that was a win for the defence, she shot herself in the foot. Because if she saw his hand coming out, or his fingers, or whatever, we don't know whether it was an arm, an hand, or fingers, which she then hit with a baseball bat, well, what did she do to prevent him getting out of the suitcase? So was it because if she was so scared because he was getting out and she had to hit him with a baseball bat to stop him getting out, well, he obviously didn't get out. And if he could have got out, but he didn't get out, then Sarah did something else to prevent him getting out. She didn't just go to bed and forget, like she said in the police interviews. So she didn't just, you know, like go upstairs and forget all about him, and then woke up and like he was still in the suitcase, and you know it was just she blacked out because she was really drunk. No, that would be manslaughter, because that's what I thought. Well, okay, you could argue manslaughter, that she didn't let him out and she goaded him, and then genuinely she forgot him. So she didn't mean to kill him. She didn't really mean to harm him, but it was just tragic that she fell asleep. So you could argue manslaughter there. However, now what she's doing is saying, I was so scared because he was getting out of the suitcase and I was threatened by that. And you know, it was my, you know, the stand your ground defense, that you can act first. If you know that someone is going to cause you serious harm, you can act first to stop them. You can use, in my country, we call it reasonable force. You can use reasonable force to prevent a crime towards yourself or towards anyone else. You can use reasonable force to stop them. Now, the definition of reasonable force is vague, and it's purposefully vague because it allows for, well, what's reasonable in what circumstance? So if someone's coming at you with a knife or pointing a gun at you, then your life is in danger. So if you have to take a drastic step to protect yourself, then okay, that's reasonable force. But if someone just bumps into you and then you know, kill them, well, that's not reasonable, because just bumping into you, it might be offensive, but it's not life-threatening. But if you then, I don't know, laid into them and killed them, that would be unreasonable force. So it depends on the circumstances. And I'm guessing it's the same in Florida, right? So if she felt so threatened that he was getting out, and she thought he was going to, you know, beat her up and kill her, well, what did she do to stop him getting out? That then becomes an action that she did willfully. And that is then murder. In my opinion, that then becomes not manslaughter, where yes, she didn't let him out when he wanted to be let out, but she didn't do anything to help him, but she also didn't do anything to stop him. And just the fact she fell asleep was just a really tragic, unfortunate event. And yes, it was her fault, but she didn't mean to harm him. So it's manslaughter. And the plea deal that the prosecution have offered her is one of manslaughter, which has got a much reduced sentence. So her saying that I was so scared that I had to hit him with a baseball bat, well, what else did she do to prevent him getting out? What actions did she take? That's action, purposeful, intentional action that resulted in his death. And therefore, that is murder. So potentially, she has shot herself very much in the foot. Tell me if I'm wrong. Will I be watching Karen Reid's second trial? Of course I will. Of course I will. I didn't notice that, but it doesn't surprise me. That's what she said. That's what she told the cops at the time. But that's now not what she's arguing. So she never said it. No, she never said it. Never said it. Exactly. If she, and this is why I think her argument is counterproductive. So it might feel like a win for the defense now, which it is. It is a win for the defense, but it will backfire, because it's obvious that if he only had his fingers out of the suitcase or even his hand out of the suitcase, she had time to do something else other than hit him with a baseball bat and whatever else she did to prevent him getting out of that suitcase. She could have done something else. This was not the spur of the moment. Someone's pointing a gun at you and you have to act right now because all they've got to do is pull the trigger. No, it's a very different scenario than that. If she felt so threatened by him getting his fingers out of the suitcase, she had the time to run out of the house and call the cops. She had the time to go and get help. And we know that she's called the cops before on him. We know that he's, you know, the cops have been called to that house. Like, he's called cops on her, she's called cops on him. So as a, you know, as a person, she's not shy of calling the cops when she needs them. So in my opinion, it's her argumentation is going to backfire, in my opinion. But then again, it's not down to me, it's down to the jury. It's down to the jury. All right, here she comes. Here she comes. Let's just check that I've got audio on my end. Yes, I do. Okay, cool. The audio wasn't great in court yesterday. The audio's fine from the judge's point of view, but the attorneys move around. Especially Mr. Owens, he's moving around. So they need to get some kind of remote mics in. Because unless they're stood at the podium, you can't really hear them. Even when you're really concentrating, you can't really hear them. So there's nothing I can do about that, I'm afraid. There is closed captions. I have got the closed captions on. We might need it. Sarah looking dapper. Same suit, I think. Different top. Wearing yellow today. Miss America has arrived. You just found out she wants snacks. Oh yeah, the Pop-Tart scenario. I don't know whether she was granted snacks. Don't know whether she's got them. But like I said, I have zero idea, literally zero idea what this is about. I'm just messaging the peeps over on MichelleAfterDark to say I'll go live as soon as the court starts on Leilani's. She wants an expert witness to testify before the evidence is presented. There is a motion to quash that. Oh, so that's what this is about, is it? I thought the judge's ruling yesterday was very clear. They have to set the foundation first before they can bring in experts to talk about that defense. I thought that was very clear. I thought that was a good ruling. But obviously she's not happy with that, if that's indeed what this is about. All right, come on. Are we getting audio in the courtroom here?
William Shea for the state.
Here we go. We got audio. Right, I'm going to mute out here. It's not very loud, is it?
Ma'am, good morning. Can you state your full name and date of birth for record?
Muting out.
Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come up?
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Not another break. Oh, dear.
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half.
Okay. Correct.
I believe we each have 10 strikes.
That's correct.
That's going to take.
Okay. Mr. J?
I just need that ruling so that with enough time prepared.
All right, we are
I understand.
live.
So the way I see it is we've got a couple of
live.
options.
I didn't even
We
put my
can,
intro
and
on.
there's no good
because
cut this
I
out.
saw Judge
One,
Tammy.
we can
and
wait
thought,
on the
"Here,
objections,
she's
which I
here
know
on
you
time.
do not want to
For
do.
once, she's here on
Or
time."
we can stop now.
So I'm going to mute out here
Madam Court
because
Reporter can
she's
provide a rough
almost
draft
ready.
of what
Because
was
there's
ordered
an
yesterday.
issue
We can
going on
go
with
over it
Sarah
and review
Boone.
it, make sure that we're
So
all on the same
I'm
page as
over
to
on
what the
Michelle
court's
Watt,
ruling orally was
listening to
yesterday as to the various
Sarah Boone.
motions and
So you can
limine.
join me over there
Then we can
following Sarah
continue with
Boone.
jury selection,
But
or then
stay
we can
over
pick
here
up with
is
the
following
objections.
Leilani.
I'm
I'm gonna
amenable
mute
to
out.
however it is you
Court's
want
gonna
to
start very
proceed.
shortly.
I understand your concerns of running afoul with the motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Ms. Rowans? How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
All right, so a brief recess here. Did I have both mics on just before? Oh, sorry about that. So you could hear what I was saying over on Michelle After Dark. You could hear that over here. Sorry about that. I am live over on Michelle After Dark. Court is about to start for Leilani. So Law and Crime Network had their scheduler up wrong. Oh, no. Oh, no. Oh, no. Court TV have now put their "we'll be right back" sign up. So I don't know what's going on. Dear me. Dear me. All right, so we're in a brief recess here. Madam Court Reporter. Madam Court Reporter. Causing delays. I don't think it's unreasonable to ask for a playback from yesterday. I don't think it should delay the trial. You're seeing Sarah Boone on both channels. You're not seeing Sarah Boone on both channels because I've got Leilani up on Michelle After Dark. So I saw Judge Tammy. Judge Tammy popped her head up, but then promptly disappeared again. Can you hear me over there now? I've got the mic muted. Oh, I know why. I know why. There we go. All right, should be sorted now. Should be sorted now. I forgot to change the mic over. So you were actually hearing it through the laptop, not through, you weren't hearing it through the mic, you were hearing it through the laptop mic. So I'm sorry about that. All right, we're all sorted now, don't worry. Yeah, it's difficult to do two at once. However, it will get easier. And we might as well have these teething problems while Sarah Boone is messing around. They're still not finished jury selection. And what? So what are they trying to do? What are they trying to do? Seriously, what are they trying to do? I understand. I do understand that they need some kind of, record of what was said yesterday. Get that. So this is a good fix. Give them the audio so they can play it back. I'm not sure that a 15-minute recess is going to be enough. Because it's like 9:30 there now. It's gone 9:30 there now. So the recess was until 9:45. But we'll see. We'll see. Well, right, let's do a little experiment. Whilst we're waiting for the court, right, I'm going to turn both mics on. Do you get an echo? Like when both mics are on, do you get an echo? Like, I'm going to do it now. All right, guys, so I've got both mics on. So you should be hearing me on both channels. So you don't get an echo. All right, that's great. So I can talk to both rooms at the same time. I was worrying that if I talked to both rooms at the same time, there would be some reverb or something would happen. So there's no echo. Pincho says, yes, you get an echo. Linda says, no echo. Pincho says, echo, echo. And then over on MichelleAfterDark, there's no echo. So, Pincho, you seem to be in the minority. I don't know why. Oh, Muslim does an echo. Down Under with Love has no echo. I don't know. Oh, so there's no echo unless you're listening to both streams. So if you've got both streams open, then you're going to get an echo. You're going to get something. But if you're only listening to one, if you're only in one room, then you won't get an echo. Well, that's good. Because if you are in both rooms, if you are doing what I'm doing and watching both trials at the same time, if you just mute one, like obviously while the trial's going on, while the court's in session, I'll mute out anyway. So if while I'm talking, while both courts are on a break or doing something weird while we're waiting, I might as well talk to both rooms. So if you mute one, you should be fine. But it'll be good. It's good that I get to talk to both rooms at the same time. So no echo on either one, so that's good. But if you are in an echo, just mute one while I'm talking. But once court's in session and I mute the mics, it'll be fine. Even if you're watching both, you won't have an echo because there won't be any sound coming from me. Good stuff. All right, that's made my life so much easier rather than trying to, spend a little bit of time here and a little bit of time there. It does make more sense to talk to everybody at once whilst we're in these lulls. Michelle, the super streamer. Yeah. Michelle says mute the same way someone would say do one. What? Mute. Some people go mute. Some people say moot. So I don't know. Oh, is anybody following the Menendez brothers thing that's going on? Like the campaign to free them. I watched the press conference. So it was the attorney for Lyle Menendez and the family, and all the family want them released. And the new information that's come out, wow. Who are they? They are two brothers, Lyle and Eric Menendez. So this is in the 1990s. So we're going back like 30 odd years. They murdered the parents. They shot them. So there wasn't a. First of all, they lied. They basically made this story up that they were at the movies and somebody had come in and shot them, and then they made this 911 call, like all shocked and upset and crying. So there was lies in the beginning, and finally, when the cops realized it was them, they admitted they did it. So by the time it got to trial, oh, all right. So we've got court in session for Leilani. So if you want to go and watch Leilani, then court is in session. So I'm going to mute out on Michelle After Dark, but I'm going to carry on talking on Michelle Walks. All right, so I'm just talking to you guys on Michelle Walks now because court is now in session for Leilani Simon. All right, so the Menendez brothers. So finally, they admitted that they did it. But when it went to trial, it all came out that they'd suffered from years and years of horrendous abuse. Like emotional abuse. The father, Jose, was so controlling and horrible, and the mother just wasn't interested. She didn't want to have kids, really. She was just really, disengaged. And then it also came out that he'd been sexually abusing them. So first of all, Lyle, who was the eldest, and then Eric. And he was still abusing Eric well into Eric's teenage years. So they actually claimed self-defense, that they believed that the parents were going to kill them. So they were proactive and shot them both dead. Yeah, Leilani is on now. Yeah, Leilani is on. So I'm gonna play the press conference at some point, and we can have a chat about it. So I'm going to mute out over here, so I can listen to Leilani, and also you can probably hear the judge talking right now. But Daniel Youngkin's about to resume his testimony, so I want to listen hard. So I'm going to mute out here right now. And hopefully we should be back in session here anyway in the next 5 minutes, if they're on time. All right, muting out.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
James Owens for Sarah Boone. Tony Anderson for Sarah Boone. Mr. Beck.
Okay, Ms. Boone is seated at council's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure.
I didn't know.
Madam Clerk's providing you a printed copy, sir.
Thank you, ma'am.
Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it. Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916-7-2-750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just my understanding, clear on the record. It's just procedurally. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from the state.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point, for the record, for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with for dire nor opening statement.
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that 5th amended reciprocal discovery exhibit list filed by the defense I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, the defense
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them, so we provided those to the state as soon as we were aware that we had not.
And what do the 119 pages evidence?
medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of George Torres.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
My understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week? Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge, not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time. Appreciate it.
I've got staff here in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on response.
The objection sustained. Moving to 6. Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 223:20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing this exhibit. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course experts can rely on inadmissible evidence if within the course of that area of expertise it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take another deposition. So I'll wait. I will not have her review.
Okay. State with.
That was the only purpose.
Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, and Massachusetts. We're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries, photographs, officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits, and that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I've seen Dr. Crump will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. Her family can't help her, she has no attorney dropped 3 of the charges. 3 separate times, George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Williams says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
We don't intend to introduce anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge Brian Boone, we anticipate is going to testify for the state, and testify for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that force,
What does
what he says.
what does the non-payment of alimony have to do with what's happening in a family case?
Well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has an that shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. And I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment? All right, thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
This does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG _ embedded _ 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Any and all exhibits previously listed by the state?
Mm-hmm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense, that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only two people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
I don't know.
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
It would be good to know how long the recess would be, but we're going to stay muted on this channel because Daniel Youngkin is still giving testimony over in Leilani's channel and Leilani's channel, my other channel, Leilani's trial. And the defense attorney is giving him a really bad time. So I'm a little bit hooked on it at the minute. So I'll stay muted out here so that there's no, I don't know, issues. So, all right, muted. Yeah, they did say the deal was what the deal was. They said that they downgrade the charges to manslaughter, and she would get 15 years. So they were offering her a 15-year deal. However, there would have been the possibility, assuming that the judge agreed with it, for her to have got parole well before the 15 years. And she's already done 4.5 years. So she's got 4.5 years time served. So even if she wasn't granted parole early, she'd still only have 10.5 years to serve. But she's going for all or nothing. She's going for broke. She should have taken it. She absolutely should have taken it. She absolutely should have taken it. But she knows better. So we'll see. We'll see how it goes for her, won't we? All right, muting out. I know. Yeah, my patience is wearing very thin with this this case. Just get the trial going. I mean, look, I want them to, have all the things ironed out, and to be no loopholes that Sarah could try and jump through on appeal. But at the same time, I think the defence is delaying, and I understand why he is, because he's only been on the case since August the 30th. So he's had a lot of catching up to do. The judge, rightly in my opinion, denied his continuance. He wanted a continuance. And because the trial's been going on, like the prospect of it for 4.5 years, and there's been delay after delay after delay, there comes a point where you say, no more. This is happening now. And so I think that's partly the reason why Mr. Owens is doing what he's doing. That he is being nitpicky, saying, "Oh well, we were never told what she's actually been charged with, what they actually have." And it's like, yes, you have. You know exactly. But to have got all the way through the discovery and to have to have ideas for counter for all of it, it's a tall order to do in a month and a half. But that's what he signed up for. Now, I think by the sounds of what he said on some interviews on, I think, Court TV, he expected to be able to get Sarah to take a plea. I don't think he realised that she was going to be so hard-faced and was going to take it all the way to trial. So now he's stuck between a rock and a hard place. Yeah, Judge is ready to move on, but Owens is pushing for more time. He is, and you see why. But he's got himself into this position, and if he can't handle it, then he needs to say so. For whatever reason, he jumped into this case. He answered Sarah's advert, and now here we are. He's not got his plea deal. Well, he could have had. Sarah could have had a very generous plea deal. That was on the table, and I assume it's still on the table. However, Sarah doesn't want it. So the attorney wanted it, but Sarah didn't want it. And ultimately, it's her choice. So he's got to take this thing to trial now. So anyway, I'm assuming they're going to be back soon. I mean, he just said how long is a brief recess? I like to have a time frame in mind. But anyway, I'm going to mute back out and go over to Leilani. Oh, looks like we're going to be back on the record here right now. All right, cool. All right. Hopefully, this doesn't take too much longer and they can get back to jury selection.
All right, we're back on the record. Case
Right.
number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that Jury Services has told us the juror in seat 25 wearing badge 63 called. Is it John? The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the Order Tennis motion as to Ms. Boone's request for snacks, the Order Tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
All right. So I assume when they're back at 1 p.m., they're going to be resuming jury selection. That seems to be what's happening. So I'll log off here. Did I hear correctly that he's going to have some kind of Richardson hearing tomorrow morning? I'm not confident we're going to have trial starting tomorrow. Yeah, snacks denied. Snacks denied. Oh no, what's she gonna do? Look, I'm a self-confessed sugar addict. Sugar is life. I couldn't live without carbs. So I do feel a little bit sorry for her. But then again, she is in jail and I'm not. So there is that. All right, I'm going to log off here. If there's any further news from the Sarah Boone camp, I will report it over on Michelle After Dark in the breaks of Leilani. So we've already had the mid-morning break over in Leilani land. Daniel Youngkin is still on the stand. Cross-examination's over. The prosecutor's now rebutting. And I think he's going to be there for a little while yet. Don't know who's coming on next. So hopefully I'll see at least some of you over there if you're following Leilani. All right, guys. So logging off here and see you soon.